So though they are violating the Voting Rights Act, they are acting under the pretense of seeking to comply with the law based on a letter that was sent to the Texas government by Attorney General Pam Bondi, perhaps the most unqualified Attorney General in U.S. history. In that letter, she misstated the law in a number of different respects. First of all, she interpreted a decision about what the Voting Rights Act might require as somehow meaning that even though the Fifth Circuit decided coalition districts are not required under the Voting Rights Act, that somehow meant that if you created coalition districts, it was unlawful. That is false. It is impossible not to create coalition districts in a state like Texas with significant populations of Latinos, Blacks, and Asian Americans often living in close proximity to each other. She also argued that somehow there was racial gerrymandering going on when the state of Texas, throughout the current litigation, more on that in a minute, about the current map, has asserted, apparently without real cause, that they did not consider race at all in drawing the current maps adopted in 2021, that they did this race blind. We knew that was false. But on the other hand, Bondi tells them that they engaged in racial gerrymandering, which is by definition the over-consideration of race, and they decided that they then must redraw the lines, even though they had asserted all along that they never considered race. The last point is that the United States was a part of the current challenge to the current maps prior to the Trump administration. When the Trump administration came into office, the United States decided to abandon their case against the current maps. So for Pam Bondi to then follow with a threat to sue is simply false. The United States, like all litigants in federal court, does not get to bring certain claims on a matter and then decide later on, oh, no, we have other claims we want to bring. That's called claim splitting. It's not allowed. The United States could not sue, having abandoned their pre-existing lawsuit on the current Texas redistricting maps. The final thing I want you to know is that there will be a voting rights challenge to this map once it is adopted. Indeed, the three judges who just heard the trial in the case challenging the 2021 maps, indeed, we were in the middle of post-trial briefing when they decided to suspend that briefing, in part because there might be a new congressional map. But the parties have gone to those three judges and already requested a hearing for a preliminary injunction motion to prevent these new maps from going into effect for the 2026 election. Indeed, there will be a hearing this coming Wednesday with those three judges to decide when that preliminary injunction hearing will occur, whether in September or October. We are arguing for September because we need this resolved in time before the 2026 election begins in earnest.